Hi everyone, it's Grant Abbott speaking. Welcome to this session. It's a short one. It's on non-foreign purchaser discretionary trusts. It really comes about from a lot of changes that were made in 2016 following the Chinese and other, I shouldn't be racist and say that, but the Chinese and other Asian companies, individuals, and also overseas individuals buying up Australian land, effectively not renting it out, then just living over and leaving it dead and buried. So to prevent that or limit it, obviously there was some vacancy taxes which were put into play. But essentially what we had there, a very funny Tim, the Kung Flu. Yeah, so essentially what we had in there is that the various state governments latched onto it. I'm not sure, I think it might have been New South Wales, but once one does it, then they all do it. And they introduced a stamp duty surcharge for foreign purchases. But you'll see when we go through the legislation, it's actually flipped around so that particularly where you're looking at discretionary trusts, it is assumed, and this is quite interesting, it is assumed that if there is a purchase through a discretionary trust, that a foreign purchaser somehow is benefiting more than 50% of the entitlements of the discretionary trust as the appointer or the trustee. And it's now up to the advisor or the accountant to go to OSR and provide or produce the relevant documentation to ensure that a foreign purchaser is not involved. It's not only that, I went through the process at the moment with my mum and dad who've lived in Australia for a long, long time, had their house of 30 years. They're both in a home at the moment. So we just sold the property. And again, we had to get a tax office clearance that the money wasn't going to go overseas. Otherwise, there would have been a withholding. So certainly they're tightening up everywhere. And also it's almost as if everyone is not guilty, but everyone's assumed to be a foreign national. And then they're treated as that. And then it's up to us to prove it, which in one state, it's not a bad idea from an accountant's point of view, is that you are right at that firing line and understand what's going on. Let's go and have a look at the next slide. So this is a slide on the foreign purchaser duty surcharge. I will put this up on the strategy centre later this morning, and then I'll put this up as a PDF. So it's a really good handy guide for you on that one. So Victoria, you can see all of them are residential property. Tasmania includes primary production. That's the only state that does so. Types of foreign person, individuals, companies and trustees. I'm going to look through the Queensland legislation just to show you exactly how that fits in. Might even get my little spotlight out so we can see it. So I'm going to look through the Queensland legislation because it's all much the same. So the 2018 rate, I think a couple of the ones might have jumped up, but you can see there, well, there you go, it was Victoria was the first one to introduce. I thought it was New South Wales, was actually Victoria. And then that was followed by New South Wales, then Queensland, actually before that, and then all the rest after that. So the stamp duty surcharge is 7%. 8% obviously New South Wales and elsewhere, a lot less for Tasmania. Now the maximum rate depends on the size of the property. You can see it can be actually quite significant, and I'm sure the government's made a few quid out of that one. Let's have a look at the legislation just briefly, and it's all much the same throughout. So I'm just going to go through this really quickly, but essentially AFAD, residential land, which is the foreign acquisition, is land in Queensland that is or will or solely or primarily used for residential purposes. So it's obviously resi land, and to which any of the following applies. On the land there is or will be constructed a building designed approved by a local government for a single family unit. On the land there's a building that will be refurbished, renovate or extended. The land is a lot in which there is a building or part of building that for the separate area that the lot comprises is designed to or approved by local government for human habitation. I won't go through much, but you can see virtually it's a pretty big sweep to come up that, and even down here, which is pretty important. a person is undertaking or will undertake development of the land, so it becomes land mentioned in any of the subparagraphs 1 to 4. And it's that generally, if you remember going back, and I think New South Wales was the right one to do it. I remember looking at a property in New South Wales and Sydney. This would have been 2015, and it was on Macquarie Street. It was a 3-bedder, beautiful views of the harbour, etc. And it was going to go for 2.5. I turned up to the auction. I was going to bid maybe 2.5 for it. Ended up going for 3.5 to a 19-year-old Chinese student who obviously was working on behalf of parents or parents' money. Now, that was happening everywhere, and I remember some of the ridiculous prices that were going out at Earlwood for blocks of land and Chatswood, where people could then make those townhouses, then sell them off to the Chinese. So that's where the government basically got in on the act and started to also hold on it. Even if it's land, if you're doing anything that is remotely going to be resi, then effectively what we're going to do there is put a surcharge. And of course, the underlying thematic there is, well, we want to have those land and all that for our children, etc. Not that anyone can afford a property at the moment. So, who is an acquirer? So, for a dutiable transaction mentioned in 9(1) A or B, is a transferee of the dutiable property under the transaction. So, if you receive the property, then you have to pay, obviously, stamp duty on it, which is important. For us, if we have a look down here, so if I have a look at subsection E, for dutiable transactions specified in section 9(1)H, which is the trust transaction, there's the creation of a trust of dutiable property, which is obviously the land. A person who, under the transaction, who starts to hold the dutiable property in a way mentioned in section 53. So, for example, if I did an LRBA and put it into a holding trust, then there would be stamp duty on that, because suddenly I've got it held in a trust at that sort of stage. But I'd have to prove that it's a non-foreign purchaser. For a dutiable transaction in 9(1)H, so termination of trust is also the case. So if we terminate a trust, so we vest the trust and it comes out to an individual, then in those circumstances, again, there's obviously going to be this surcharge stamp duty. And this is probably the one that's most for us. For a dutiable transaction mentioned in 9(1)I, that is a trust acquisition, a person who makes a trust acquisition under the transaction. So that's essentially where the trustee decides to enter into a transaction to acquire property. So what is a foreign trust? And this is the key area for us, and it's the same, honestly. I've checked all the legislation, it's all basically the same. So one does it and then everyone follows it. So trust is a foreign trust if at least 50%. I'll compare that to a suit or the in-house assets where it's 50% or more. Here it's at least 50% of the trust interests in the trust are foreign interests. In this section, foreign interest means a trust interest of a foreign individual, or a trust interest of a foreign corporation, or a trust interest of a trustee in a foreign trust, or a trust interest held by a related person of a person mentioned in paragraph A to C. So when we have a look at that, essentially those trust interests is going to be down to the beneficiaries. Now, the way they map that through, if it's a discretionary trust, and they all have their own little examples on it, is you flow through to actually see who the beneficiaries are. So what we've got from that one is, I'll just bounce out of there, and I'll show you what we've got up on the LightYear site. I'll come back to the distribution minutes, as I said before. Just as an aside on this one, you'll find that we are getting so many new documents up on board. The easiest way is generally just to do a search. So if I go for non, so he says, and then it doesn't pop up, does it? Let me just see. No, it doesn't look as though it's going to pop up. So if I just go foreign, if I could spell foreign, it'd be much easier. Okay, so again, just use the search, because otherwise we're just putting so many documents up. It's a lot easier just to go in there, or alternatively, see the support ticket, just say, look, I'm doing this. What document should I use? I'm on the top level, the LY strategist, and I'm starting the document now. I find my folder, so I'm going to use it, the Abbott test folder. Now this is an establishment, and I'll show you a bit later where the variations are. So this is essentially an establishment of a discretionary trust, but we use this if we're establishing the trust and then we're going to acquire property. So if you're going to acquire property in 6 to 12 months, or your client is, then you would use this. Now, I haven't set up the discretionary one yet. I've just done the leading member. So I'll do that, but we will be rolling out the discretionary one a little bit later on. Now, it's gone into my folder, the Abbott test, so I need to put in there the name of it so it's easy to be retrieved. So Smith Non-FP Trust. Again, use Abbott Morley if you want, or you can have no logo, or alternatively just put your own logo on there. If you haven't had the chance to get your documents white labelled, tomorrow is our logo day, so please just send them in. In fact, just flick them on support, put on there your name, your email address. I'd like to have this logo white labelled. Put the attachment, make sure it's a high-res version of your logo, send it off to us, and then what we'll do is we'll then come back, our team will come back and give you a five character code, which you can then put in there, and that instantly puts in your logo. So let's go down to the general. Obviously, we put in the name, the Smith. Now, we could go to family trust, so we could go to Smith Family Trust, that's okay. When will the trust be established? We'll do that today. Which state? We're going to do it in, I'll do it in Queensland. No, I'll do it in New South Wales because my fingers will go there. Now we have to, you'll see this throughout our interview sections, is that at the end of the trust, so the end of the trust period, which for Queensland is 80 years. South Australia, there is no end. What happens is that at the end of the trust, we vest the trust, and all the benefits, all the beneficiaries include past, prior, or relatives, etc. If there's no beneficiaries, then we need to put it into a charity. So just choose your relative charity. So I've got RSPCA, and I'll make that New South Wales. Okay, I've got the set law. Just a couple of lines on that one. It's pretty easy. So just put John James. Now, make sure as an advisor, you don't settle the trust. There's just a couple of, look, I haven't gone in deep dive into the research, but there's a couple of lawyers there who believe that effectively, if you are the settlor, you can't advise the trust because of conflict of interest. So just get one of your youngsters to do that. It doesn't matter. I mean, they're just settling the property. And we take it from there. Now, the trustee, we've set up a company. For this one, it would obviously just put our Pty Limited, prefer that one. For our company, what we would do is use our leading member discretionary trust company, which is a special purpose one for that. So it's special purpose that you don't get the lower fees, but essentially on if there's a resignation of the leading member, we're about to go into the appointors. There's a resignation of leading member appointor, they retire, they get separated, so they want to retire or resign as leading member appointor. They go bankrupt, they want to resign as leading member appointor. They die, they become incapacitated. Then effectively what will happen is it moves, the shares are cancelled and move on to the next leading member in line. And you know what I'm like with that. Most importantly is our succession. So let's go through there. We've got a couple of directors here. So I'll just put 2 there. I need to confirm. And then I've got John Smith, and we've got his spouse, Sally Smith. Now, do they want to sign on behalf? Absolutely. And then we go down to the leading member appointor. Now, if you really, at the end of the day, there's not a huge difference. Well, there is actually. I'll show you where the differences are. But if you're going to do a discretionary trust, I would argue that you're probably better off doing a leading member. Now, you can do a joint appointor, husband and wife. If I wanted John and Sally, But the problem about that lacks control, because if Sally just says to John, well, I want to leave, I want to go and find myself and stuff like that, then having joint, you've just lost the whole power of being a leading member. So I'm going to go no, and you'll see you always have to, you can't just leave these things open, otherwise what happens is you end up with code. So it's going to be an individual, and we've got John Smith there. We are, for those of you who don't know, we are doing a capital raising at the moment and getting and I'll go, do you wish to automatically appoint the second leading member? Yes. Is there going to be joint? I'd say no. Now what I'm going to use there is Max, so that's John's son. He lives at Brown Street, Melbourne. 3,000. So the capital raising we're doing at the moment, and we can put a third one in there if we want. I'll just go no. So the key for that is, there's a new. So what you can see here, this iframe, see all the grey area, that's Hot Docs, which we've got a perpetual license on that one. And we're about to get the next level up. So this is about 20 years old, but it's a great little, because honestly, it's the best system I've ever seen in my life, personally, in terms of being able to toss out a lot of information. For those of you, I'll show you, I did a session the other day. It's the future of where we're all going. So I'd strongly recommend you watch this session. I'll show you in a second on that one. But around that one is we will be upgrading to the next level, which will enable us to warehouse names and addresses, etc., so we can then make this even an easier process. So are there any of the primary beneficiaries a company? I would say I'd go no on that one, because the problem is then you'll end up having, look, you can put the company in a little bit later on, but otherwise you're going to have to do a look through and prove that the company itself, because remember we looked through the legislation, the company itself can also be caught up potentially as a foreign company. So you don't want to get involved with that, in the same way you don't want any of this as well. So that's it. So really, Grant's been gabbing on and it's up and running. And so we're looking at the establishment here. And we're going to see from this one that up will pop our leading member non-foreign purchaser trust. So this will apply in all states. So leading member discretionary trust for non-foreign purchasers. So I did that because I want it smashed into the face up front, so that if you do have to go and get it stamped, or when you get it stamped, that, although in Queensland you don't need to get things stamped, deeds, but it's not for foreign purchasers. So most of you have seen our deed. I'll just go through a couple of ones there anyway, and this will do a nice segue anyway to our session on, for those of you who want to stay around for trust distribution minutes. So we got the deed. Remember, I put in 25th of June. I've got the set law, who's the youngster at my office. We've got the trustee there, and we've got the leading member appointer. So again, the settlor wishes to create a settlement, the trustees agree to act. So this is all the normal stuff. Now, the big one is the beneficiaries, the trustee, the appointer, and any other person associated with this trust are not a foreign purchaser or deemed to be a foreign purchaser under the various state foreign purchaser stamp duty surcharges or land tax surcharges. So we've put that basically up front as a deed. And importantly, when we have a look at the strength of the law, so for example, Tim and I might say, okay, we're going to do a handshake deal on something. And so we handshake and do that, but then it all comes down to being the word of a gentleman. I'm lucky that Tim's very much a gentleman. Hopefully I am. Well, I am too. I can tell you, don't do dishonest things. So we do a handshake deal, and that's okay, but it really hasn't got much strength. You know, at the end of the day, if Tim reneges, they're not going to have to take him to court, but what evidence do I have? The next level up is it's going to be a contract. So if we have a look at a contract law, then effectively, you know, Tim and I say, well, this is going to happen, this is going to happen, and then this, then this, then this, then this. And then what happens from that is we both sign and then it's off and running, which is not a bad thing. But then, so that's bound by contract law, and then above that is the deed, which is the most solemn of documents. So when you're entering into a deed, it's hardcore. It's like, this is what it is, this is what it is, and you must abide by it. And if there's any infractions, then you can take an equitable action against the other parties for those infractions. So that's why we tend to use deeds a lot. So here we're making this, we're putting it right up in the face. You'll see, I'll just go through a couple of sections here. Remember, the leading member appointor means John Smith of 5 Smith Street. In the case of incapacity, resignation, or death of the person, the next in line leading member is Max Smith. In the event there is no leading member appointer, the trustee is off the roll to a beneficiary of the trust who is a descendant of the original leading member appointor. So that has to be John Smith. And when we're talking about descendant, that's obviously bloodline, just descendant his bloodline. That offered person must accept and become the next leading member appointor. It also includes such other person give the power to appoint or remove trustee by blah, blah, blah. Beneficiary, we've got here, what's a foreign purchaser? Who is a non-Australian citizen or a trust where the trustee or appointed beneficiary receiving 50% or more of its capital or income distribution is a non-Australian citizen. So we put that up in there as well. We've got the income determination. So I'll look at this. Income of the trust means that amount is determined by the trustee. If the trustee makes no such determination, income means all profit or gains less expenses. So we've got quite a broad aspect there. Now, when we go down into the beneficiaries, the beneficiary of the trust shall comprise the leading member, the spouse of the leading member, any child, grandchild, or great-grandchild of the leading member, to any other relative of any leading member appointed born before the termination date. Now, the termination date is 80 years. So what this does is it automatically brings in grandchildren, future grandchildren. It doesn't matter where they are, but effectively they've got to be a relative of one of the leading member appointors. Corporations, where the leading member appointor beneficially owns a share or one of the trustees. Secondary trust, trustee or trustees of any trust whether now existing or hereinafter created, of which a beneficiary or discretionary object hereunder is a beneficiary of the trust. Superannuation funds, where the leading member appointor. And then we can just go down here. We can delete beneficiaries, and this is pretty important, particularly if you're looking at family law, family provisions. And we've got foreign beneficiaries. The trustee is not to distribute or pay any amount to a foreign purchaser, where such distribution, whether income or capital, may result in the trust being subject to foreign purchaser stamp duty. So that essentially is the big gutsy one there. It's nice to put it up front, but here, basically, the trustee can't distribute to a foreign purchaser at all. So that's essentially where we are. So that's effectively the document that you want to do. You go down the back end and you'll see the execution pages. Now, with the variation of this, I haven't put it up yet. I'm going to show you something. This is my, so you can see this is actually one of the sessions for the summit coming up. So I'm just going to drop into there you go. So here's my discretionary trust deed upgrade. So this will be launched tomorrow. So this is where you've got a variation. Hopefully it comes through. If not, I'll start it again. So DT, just let me go through. It might go here. Sometimes it gets a little bit slow because I haven't reset my computer today. When you leave these things open, let me just try it again. I'll go in, work items. There you go, see it pops up. If you leave it open for a while, it just doesn't work. So I need to put, as you can see, we're doing so many documents at the moment. We're very lucky we can do up to, with our system, probably about 100,000 documents an hour, which is one of the reasons why we can offer such great prices. Okay, so I don't think, so it looks as though, anyway, let me just go through here. Essentially, it's the same process. So I do my document setup. So this is a Smith upgrade to NFP. Essentially, you'll need this if your client has got an existing discretionary trust. And for those of you who remember, we had a look at TD or tax determination 2012/21, where the commissioner, if you've seen it before, basically says that where you replace an old set of rules with a new set of rules, as long as the underlying trust stays on foot, which is the case with our variations, then it's not a resettlement. So let me say that again. It is not a resettlement. So you never have to worry about that question again. If you're doing a split trust, then there's potential resettlement. But if you're just overlaying the rules, go for it. In fact, I would encourage everyone to go through the process of those, particularly those on LightYear, to upgrade all client SMSFs and all client family trusts, and also at the same time update all the constitutions. Even though they're existing, we're just overlaying a brand new modern set of rules. And it's better that way, you know, everything is being done properly. So we go down the general, what's the name of the trust? The Smith Family Trust. And you'll get this just straight out of the existing documents. So when was this trust established? I got one the other day that was 1982, if you can believe that. And it wasn't even a family trust and been running it as a family trust, and you know, with Bamford distributions and all that. It was never ever a trust. It was actually a trust that was built for death duties way back in the 80s, prior to the demise of death duties. So the date of the deed of variation we're going to do today. We're going to do Queensland. Again, I'll just do one RSPCA. I'm going to do Queensland for that today. Okay, so what clause allows it to, we've got to go through and have a look at it. So let's say 6.1 allows me to vary the rules, and most of them do as well. Has the trust been varied in the past? And that might include also where you've changed trustee. I'm just going to go no. So we've got a company. So again, and I'll just say, yeah, it should really, as I said, you need to upgrade, and I'll start to automate that stuff as well. Okay, 5 Smith. Brisbane, Queensland, and that's 4,000. Okay. God, how is it down in Melbourne? Got the army on the streets. Just crazy stuff going on. Thank goodness all accountants and planners were all so busy. It's fantastic. And 30 June. Hopefully you've all got your contributions going in, and they're all going into a contribution suspense account to flip the excess over to the next. So is it joint appointeur? No, remember we did this before. So it's not a, so all you're doing, all I'm doing really, and you can see this is the actual Hot Docs system. So this will come up online very shortly for you. So I'm just showing you what I work with. In fact, quite often I don't. I'll end up just using our site because I prefer the PDF to a Word doc. Is there a, do you want to appoint a, yep. So I'm going to use, is there joint? No. So Max Smith. While I'm doing all this, I'll just make sure all of you, because you're all LightYear Docs users, I'm not sure, I'll send it out a little bit later with this, so just watch out. But we do have, and this is the benefit of being with us, I won't do another one there, the potential beneficiaries. Are there any primary beneficiaries company? I can go no, but I'm going to go no. Other signing person, is there anyone else such as a founder? Quite often you just got to check with principals or an appointor. So what I'll do is I'll put in there, an appointor has to sign. So that is John Smith. Yeah, so make sure that you get to our strategy summit. It's a virtual strategy summit, so you don't need, there's nothing live. It goes for 2 days and it's amazing. So we've got some amazing speakers. I just secured today Stephen Keating, who's the new Assistant Commissioner for Superannuation at the Tax Office in self-managed super funds. And you should see the questions that I'm asking. It's none of this waffly stuff. We're getting down and right into the weeds about all the COVID stuff, their audit from that perspective. And, you know, a lot of the rubbish that's been going on, the lawyers saying, well, you shouldn't do this. Well, there you go, Steve Keating. You shouldn't do this, you shouldn't do that because you're worried about this. We're actually going to get it from the Commissioner's mouth, which, look, the Commissioner's been fantastic, very cognizant of COVID, given compliance. They're turning a blind eye for compliance issues up to 30 June 2021. You can't look for more than that, except the lawyers will always look for something to put stuff up. Anyway, so a discretionary trustee, variation of the Smith Family Trust to a leading member non-foreign purchase of discretionary trust. As I said, that'll be up and running. Much the same again. You've got all the stuff there, leading member appointor. You've got the original appointor as well. So what we've got here is it's quite clever because the original appointor has to sign off. You've got that. But then they're actually turning to the leading member appointor under these rules. So we've got here again, trustee established by this, and then we've got, remember that hardcore stuff is basically sitting up there as well. Now again, the variation of the trust rules with Commissioner's determination 2012/21. So again, we put that up front so everyone knows there's no resettlement. And then we're just going straight into the deed itself. So you can see the leading member appointor. We've given it a good overlay now. We go in here and we look for the beneficiaries, deletion of beneficiaries, and there's your foreign beneficiary term there. So that's essentially where we need to go to on that one. So we're virtually up and running on that one, so it's pretty good. So what I'll do is, I've got a question there. Yeah, so Kush, the foreign purchase stamp duty surcharge also does apply in the ACT. So good question. Okay, so what I'm going to do now is I'm just going to stop this recording